Hiya, welcome back to another video on A-Level Law. Today we're going to be talking about delegated legislation, which is on Paper 2, Lawmaking and Law of Tort. We're going to start by looking at what you need to cover on this topic, and that is types of delegated legislation, the reasons for delegated legislation, controls over delegated legislation, and then evaluation of delegated legislation. We're going to start by looking at what this actually even means. Firstly, you have to distinguish it from primary legislation. Primary legislation is law made by Parliament, the legislature. So this is acts of Parliament or statutes. They're all the same thing. They are known as primary legislation. Another name for delegated legislation is secondary legislation, and this is where it's made by other bodies, so not Parliament, where the power to legislate has been delegated to them from Parliament. So basically they've been given permission to make delegated legislation or to make secondary legislation. So it's the same thing. Secondary and delegated legislation are the same thing, but they're not primary legislation. Now, to be able to make delegated or secondary legislation, you have to have the power from an enabling act. An enabling act is a piece of primary legislation, so that always comes from Parliament. So the enabling act enables you to make delegated legislation, and it can lay out the framework for how you make that law and what limitations there may be on that and things like that, and what you can and can't do. So to make delegated legislation, you have to have the power delegated to you from an enabling act from Parliament. We're going to start by looking at the types of delegated legislation. There are three main types. The first is orders in council. These are made by the Queen and Privy Council. So the Queen is the monarch and the Privy Council are the leading ministers in the cabinet, which is the leading sort of MPs in the country, including the Prime Minister, etc. There are two main functions of orders in council, which I've broken down into administrative and emergencies. Under administrative actions, they can bring acts of Parliament into force, they can give legal effect to EU directives, they can transfer responsibility between government departments, for instance, when the Ministry of Justice was created by taking some powers from the Home Office and closing the Department of Constitutional Affairs. They can also be used to amend or update existing legislation. For instance, through the Misuse of Drugs Act, they amended the class of cannabis back down to a C and then back up to a B, I think in 2003 and then 2008. The main use of orders in council is in emergencies, and they have the power to do this under the Civil Contingencies Act 2004. And two examples where that was used was the fuel crisis in September 2000 and the Gulf War and subsequent invasion of Iraq. The second type of delegated legislation is statutory instruments. These are made by ministers, so leading MPs in the country that run the government. Statutory instruments, otherwise known as SIs, are one of the major methods of lawmaking, and approximately 3,000 are created each year. They can cover one point or many and can be short or long. There are four main types: regulations, orders, codes of practice, and rules. Don't confuse orders with orders in council. They are different, but that is slightly confusing. Regulations, a good example is the Chemicals Hazard Information and Packaging for Supply Regulations 2009. A good example of codes of practice is the Police Codes of Practice under PACE 1984, and a good example of rules are the Prison Rules 1999. The final type of delegated legislation are bylaws. You can see you can spell bylaws two different ways. These are made by local authorities and public corporations. They apply locally only, and bylaws must be approved by the relevant government department. Local authorities have the power to make bylaws under the Local Government Act 1972, and they can cover things such as parking restrictions, traffic control, dogs on beaches, the banning of alcohol in public places, and the banning of riding of bicycles in parks. Public corporations, for instance, e.g. British Airports Authority or railway companies, can make bylaws such as those covering smoking on railway carriages or security at airports, and many other things. The reasons for delegated legislation we can break down into 7 key things. A good way to remember this, it's not the greatest acronym in the world, but it's LTEACUP. You can see that down the side, LTEACUP. The first one is local knowledge. Bylaws can be used by local authorities and public corporations to make laws that really apply to the area in practice, whereas Parliament wouldn't necessarily have that information to be able to make primary legislation on that. So if you think of your local road, would Parliament really have the local knowledge to be able to decide what speed or what parking can be done down that road? Would they have the time to do that as well? Equally, Parliament lacks the technical expertise in some areas. If you go back to the example we used on that last slide about chemical regulations, I doubt many of the MPs have much specific knowledge around that. So again, they can delegate it to someone who does have the knowledge and they can make sure they get the correct law. An Act of Parliament usually takes about a year to pass on practice, so therefore it wouldn't be very good in an emergency, so primary legislation wouldn't be very good in an emergency, whereas orders in council, as we went on the last slide, can be done overnight. So they're really good in emergencies, for instance, the Gulf War or Iraq War or the fuel crisis and things like that, possibly even the coronavirus crisis we are in right now. They can also be used to make amendments. So for instance, when we saw cannabis being changed under the Misuse of Drugs Act with an order in council, you can make really quick amendments using these without having to pass a whole new primary piece of legislation, an act or a statute by Parliament. You can also ensure that there's greater consultation throughout the process. The problem with Acts of Parliament is quite often they can end up being very different to what was first proposed in the first instance and then consulted with the public in the first instance in the White and Green papers. Whereas with delegated legislation, consultation can happen throughout the entire process of the creation, which means hopefully you'll get better and more efficient laws. A good example of where they do consult people when creating a statutory instrument are the police codes of practice, in which case when they're amending these or reviewing these, they consult the police and the public extensively. Delegated legislation can also be used to update the law, for instance, where there's changes in money or interest rates and things like that. They can change it quite quickly using orders in council or other statutory instruments and things like that. Finally, parliamentary time. Parliament lack the time to be able to do all these specific things. For instance, they only pass on average about 35 Acts of Parliament primary legislation a year, whereas we know at least 3,000 statutory instruments are passed a year, let alone bylaws and orders in council added onto that. So clearly Parliament lack the time, and by freeing them up and delegating this power to make this delegate legislation to other people, they can spend the time focusing on the big issues such as the NHS, crime, courts, defence, education, health, all the things that they want to focus on instead. There are different controls over delegated legislation, and these can be divided into parliamentary and court controls. We're going to start with the parliamentary controls. The first main control is the Enabling Act. They can revoke the power to make delegated legislation at any time using a new Enabling Act. In the Enabling Act, they can also put initial limitations and control in, and they can also demand that you can consult with certain people throughout the process of creating the delegated legislation. So there's lots of controls within the Enabling Act to decide what you can and can't do, and also revoke that power if you are abusing it. All delegated legislation has to be published under the Statutory Instrument Act 1996, which says that all bylaws must be published in local papers and visible 1 month before they come into force, and all statutory instruments and orders in council also have to be published, meaning there's transparency, and these can be scrutinised by the media and other people. Resolution procedures only apply to statutory instruments. There are three types of resolution procedures, and these are the way in which the statutory instruments can be passed. The first is affirmative resolution procedure, which requires Parliament to expressly certify the delegated legislation. Only a very small number in practice actually require this procedure, and one good example is the police codes of practice. Most carry the negative resolution procedure, which automatically become law if there are no objections by Parliament within 40 days. So most statutory instruments are passed without any real scrutiny by Parliament. The final one and rarest one is super affirmative resolution procedure, which is very similar to the affirmative resolution procedure, but the Minister must consult certain bodies first. And this mainly applies to delegated legislation made under the Legislative and Regulatory Reform Act 2006. Finally, there are scrutiny committees. One good example of a scrutiny committee is the Joint Committee on Statutory Instruments. They review all statutory instruments and can draw attention based on the fact that a statutory instrument perhaps imposes a tax or a charge, has a retrospective effect, goes beyond the powers of the Enabling Act, or perhaps is unclear or defective. It can report its findings, but most importantly, cannot alter any statutory instruments. The other type of controls are done by the Queen's Bench Division of the High Court, and these are the court controls, and this is done through a process called judicial review. Judicial reviews, you can see in the bottom left box circle, is a procedure by which a court can review an administrative action by a public body in England and Wales, and they can declare delegated legislation ultra vires, which means beyond one's legal power or authority. So what we're basically saying here is the courts can actually strike down delegated legislation and say that it is ultra vires and not lawful, essentially. There are 4 types we need to look at: procedural ultra vires, substantive ultra vires for unreasonableness, and inconsistency with the Human Rights Act. Procedural ultra vires is where the correct procedure laid down in the Enabling Act was not followed. You can see that in Aylesbury mushroom case, where the Minister of Labour was setting up a training board for agriculture. He had to consult any organisation that represented a substantial number of employees in that area. He didn't consult the Mushroom Growers Association, which represented 85% of mushroom growers, and for that reason the court decided that was ultra vires, and they had to go back and look at it again and set up a new training board. Substantive ultra vires, this is where the decisional law has gone beyond the powers of the Enabling Act, so they've gone beyond what actually the Enabling Act said they could do, whereas the procedural one is they didn't follow the procedure that was laid out in terms of creating it. So going back to substantive, a good example is RV Home Secretary ex parte Fire Brigade Union. In this case, changes were made by the Home Secretary to the Criminal Injuries Compensation Scheme, were decided to have gone beyond the delegated powers given in the Criminal Justice Act, and therefore substantive ultra vires. Basically, the Minister wasn't allowed to do under the Enabling Act what he did. Substantive ultra vires for unreasonableness, this is where a decisional law is made that is so unreasonable no other body would have made it, and the main case for that is Associated Picture Houses v Wednesbury Corporation, where a cinema was given a licence only if they banned children going into a cinema on Sunday, which made no sense, so the court decided it was ultra vires for unreasonableness. And finally, inconsistency with the Human Rights Act, and this is where a court can declare that any delegated legislation to be inconsistent with the Human Rights Act, and the government are asked then to amend it, and the main case for that is Bono v Harlow DC. Finally, the advantages and disadvantages of delegated legislation. Firstly, the main advantage is it saves parliamentary time. As I said, only about 35 Acts of Parliament are passed a year, whereas we know 3,000 approximately statutory instruments are created each year, let alone add bylaws and laws and council on top of that as well. Clearly, Parliament don't have the time to create all this law as well, so that gives them the time, by delegating it, it gives them the time to focus on the main areas such as defence, health, crime, education, things like that. However, you could argue therefore that it's undemocratic, since delegated legislation is often made by bodies with no real accountability. They can't be scrutinised by Parliament, they can't be called before Parliament to account for what they've done by MPs and things like that, and you could argue that some of the bodies that make the law are undemocratic themselves because they're not elected. Secondly, the main advantage of delegated legislation is it allows access to technical expertise. A good example there is the Chemicals, Hazard Information and Packaging for Supply regulations. It's highly unlikely that a majority of the MPs in Parliament had much knowledge around that to actually create proper law or be able to scrutinise the law properly in its creation. So they delegate it to people that do. The problem with that is quite often sub-delegation. When the power to make that law gets delegated to ministers, what ministers often do is sub-delegate it to civil servants, to people below them who work for them, as ministers often lack the expertise themselves, and they delegate it to these civil servants who again aren't accountable because then they can't be called before Parliament, and the minister will often rubber stamp that law basically without really having a proper understanding of what it actually means or says. The next advantage is it allows consultation throughout the process. As I said earlier, primary legislation doesn't always reflect what was initially proposed in the original consultation in the White and Green papers, whereas delegated legislation, consultation can take place throughout the entire process, and a good example of that is the Police Codes of Practice. Unfortunately, delegated legislation can often be incredibly complex and difficult to understand with difficult wording, meaning that might be difficult for lay people without a legal training to understand it. Finally, delegated legislation allows for quick lawmaking. This is particularly relevant to orders in council and emergencies under the Civil Contingencies Act, for instance the fuel crisis, Gulf War and subsequent invasion of Iraq, and you can go into detail there as to why it's needed to have law quickly in emergencies and not wait, as I said, up to about a year for an Act of Parliament to be passed. But there is a large volume and a huge lack of publicity. Whilst all officially has to be published, it's rarely covered by the media, and a large volume makes proper scrutiny difficult, if not impossible. I hope you found that useful. If you did, please subscribe to us on YouTube and visit us on Instagram at law@Portsmouth College. Thank you very much.